We completed the charge provisions and the four kinds of trial. We discussed about session trial, warrant trial, summon trial, summary trial. Now, in the trial processes, there are some safeguards, some requirements, the power of the court, etc., which we'll find. So, those the general provisions with relating to trial which are there in the BNSS, we are going to discuss them one by one. Some of the parts are not that frequently used provisions, some provision which use more frequently. So I'll give you sense or idea the manner in which it's being used in the criminal trial. So the first is your chapter 24 is attendance of persons confined or detained in prison. So suppose someone is already in custody in jail somewhere, how they can be brought before the court, etc. So you have around six sections are there. In CRPC, it was from section 266 to 271. In BNSS, this is from 301 to 306. Those general provision which are there. So in the criminal trial, if the accused are in custody, how to bring them. So let me see what are the things or procedures are there. So 301 talk about the definitions. 3.2 power to require attendance of prisoners. 3.3 power of the state government. Officer in charge of the prison. 304 and 305 talk about the prisons to be brought to the court in custody. 306 power to issue commission for examination of witnesses in prison. So these are six sections which are there in this chapter, which talk about how this accused is involved in some other crimes, etc., can be brought. So let me see first section 301, you talk about the definition. And so in this chapter implies from 301 to 306. And in this chapter, detained include detained under any law for the preventive detentions. It define prison. It define any other reformatory systems like Boston institutions, etc. 302 is a power of to require attendance of the prisoners. So suppose if the prisoners are there in some jail or some other correctional homes, etc., the court can ask the pass the order for bringing those prisoners to the court. So clause 1 says of 302 that whenever in a course of an inquiry, trial, or proceeding under this Sanhita, it appears to criminal court A that the persons confined or detained in a prison should be brought. So we require to bring those persons before the court for answering the charge of an offense or for the purpose of any other proceeding against him, or B, that it is necessary for the end of justice to examine such person as a witness. So in both the ways, whether someone who is there in the jail whom you require to bring as an accused, or you require to bring as a witness, in both the circumstances, what court will do? The court may make an order requiring the officer in charge of a prison to produce such person before the court, answering to the charge or for the purpose of such proceeding or for giving evidences. So that persons will bring by the officer in charge of that prison for answering those charges. Clause 2 says, where an order under subsection 1 is made by the magistrate of second class, it shall not be forwarded to or acted upon by the officer in charge of a prison unless it is countersigned by the CGM. Now, remember in West Bengal, we don't have any judicial magistrate second class. Second class, if the second class is passing those kinds of order, it require a counter signature from the CGM. Clause 3 says every order submitted to counter signing under subsection 2 shall be accompanied by a statement of fact which in the opinion of the magistrate render the order necessary, and the CGM to whom it is submitted may, after considering such statement, decline to countersign the order. That's the liberty of the CGM to decide whether to sign it or to decline the signing. Both the CGM can do. Now 303. Third section is about power of state government or the central government to exclude certain persons from operation of the section 302. So the state government or central government, as the case may be, may at any time having regard to the matter specified in subsection 2 by general or special order direct that any persons or class of persons shall not be removed from the prison in which he or they may be confined or detained, and thereupon, so long as the order remain in force, no order made under subsection 302, under section 302, whether before or after the order of the state government or the central government shall have effect in respect of such person or class of persons. So state government gets some upper hand in respect of the prisoners who are there in the prison. Then these procedural requirements are there. 304 talk about officer in charge of the prison to abstain from carrying out order in certain contingencies. So in these kinds of contingencies like the sickness or infirmity or unfitness, committal for trial is in custody for a period which expire before the expiration of the time. Persons to whom an order made by the state government or the central government under section 303, those basically proceeding. 305, prisoners to be brought to the court in custody. So persons can be brought to the court, and accordingly, if those kinds of order had been seen earlier, the persons can be brought to the court, and accordingly, court can pass appropriate order. So says and shall cause him to be kept in custody or in or near the court until he has been examined or until the court authorize him to be taken back to the prison in which he was confined or detained. And the last section is about the commission for examination of witness in prison. You remember in the BNSS, we have entire chapter, it was there in CRPC also, which relate to appointment of the commission. Now, in under the CPC, while this provision for commissions are frequently used, but we don't find much cases under the IPC or other law where these commission appointments are being done. But the provision is there for under 306. So that's the one chapter. Now that's up 300 to 306, the general provisions in 6 sections talking about the with person who are there in jail. 25 talk about evidence in inquiries and trial. Now this is the main sections, be recorded, etc. So this is these sections in respect of recording of the statement. Chapter 25 is the most important chapter in respect of conducting trial, etc. So what this chapter is talking about? So from 307 onwards, you will find a large number of sections are there till 318. So these are the chapter which talk about the procedure or process in which are trials being conducted. So 307, language of the court. We know every state determined the language, local language of the court. Remember, in most of the places in India, the local court or lower courts are conducted in the local languages, and those are the language of the court, or multiple languages, like it can be Bengali, Hindi, English. All three are the court's language. So 307 says the state government may determine what shall be the, for the purpose of this Sanhita, the language of each court within the state other than the high court. So other than the high court, in each state, what is the language of the court? So state government prerogatives. Now 308, general principles. If evidence to be taken in presence of the accused. But now under the new Sanhita, we also have adopted, so this is general rule. There are exceptions. So in BNSS section 356, permit in absentia trial of all those cases where the accused has been declared proclaimed offender. So 308 says, except as otherwise expressly provided, All evidence taken in the course of the trial or other proceedings shall be taken in the presence of the accused, or when his personal attendance is dispensed with in the presence of his advocate, including through audio, video, electronic means, at the designated place to be notified by the state government. Then it says proviso provided that where the evidence of a woman below the age of 18 years who is alleged to have been subjected to rape or any other sexual offense is to be recorded, the court may take appropriate measures to ensure that such woman is not confronted by the accused, while at the same time ensuring the rights of cross examination of the accused. Now, this is a beautiful safeguard which has been provided in these provisions. So, it is in respect of the women below the age of 18 years. Now, if a woman age of 18 years who is giving evidence, who is victim, then in all probability, those cases will be under POXO. When the cases will be under the POXO, so there is a separate safeguard. But in case if it started other than the POXO, then this is a good provision because these safeguards will be available. As a general right, Atmaram versus State of Rajasthan, rights of the accused. So, rights of the accused under 373 with respect to evidence to be taken in his presence is a valuable right. However, any infringement thereof is curable and would not vitiate the trial. So, very important right is there that the evidence will be in presence of the accused. But if there are omissions, etc., these are all curable omissions. So, it's not, it will not vitiate the trial completely. Court having regard to expression except as otherwise expressly provided as occurring in section 273, held exceptions to the application of 273 CRPC must be those which are expressly provided in CRPC, like section 299 under the BNSS 335 and section 317 which is under BNSS 355. In circumstances mentioned in those sections, that is 299, 307 CRPC, court should be justified in recording evidence in the absence of accused in view of the use of words in the later part of section 273, that is, when his personal attendance personal attendance dispensed with presence of his pleader, further held that in this later section 273 also provide for situation in which the evidence could be recorded in absence of the accused. So court has referred to that. 319. Now, recording of in summon cases and inquiries. So, how this recording will be taken place in summon cases and how the inquiry shall be conducted. So, 310 says, in all summon cases tried before a magistrate, in all inquiries under section 164 to 167, and in all proceedings 491 or otherwise, the magistrate shall, at the examination of which witnesses proceed, make a memorandum of the substance of the evidence in the language of the court. So, whatever the evidence they have given, the court shall prepare a memorandum of the statement. Then it says, provided that the magistrate is unable to make such a memorandum himself, he shall, after recording the reasons of his inability, cause such memorandum be made in writing from his dictation in the open court. Such memorandum shall be signed by the magistrate and shall be form part of the record. That is the basic procedure. Then 310, record in warrant cases. In earlier class, we discussed about the warrant cases and In warrant cases, two ways the law has defined warrant in cases which institute on police report or which is other than police report. So, how to do the recording in warrant cases? 310 says in all warrant cases tried before magistrate, the evidence of each witness shall, as his examinations proceeds, be taken down in writing either by magistrate himself or by his dictation in open court, or where he is unable to do so owing to a physical or other incapacity under his directions, and superintendence by any officer of the court appointed by him in this behalf, provided that evidence of a witness under this subsection may also be recorded by audio, video, electronic means. Now, this is important. Now, almost every single processes under the BNSS has permitted those processes, the evidence can be recorded by audio, video, electronic means. Clause 3 says, such evidence shall ordinarily be taken down in the form of narrative, but the magistrate may, in his discretion, take down or cause to be taken any part of such evidence in the form of question answer. So now there is no hard and fast rule that in which form you will write, and all those evidence will be part of court record. So these are all process of recording of evidence. 311 says the record in trial before the court of session. So we have seen summon case, then warrant case, now session trial. And it says in all trials before a court of session, the evidence of each witness shall, as his examination proceed, be taken down in writing either by presiding judge himself or by his dictation in open court or under his directions and superintendence by other officer of the court appointed by him in this behalf. Such evidence shall ordinarily be taken down in the form of narratives, but the presiding judge may, in his discretion, take down or cause to be taken down any part of such evidence in the form of questions and answer. The evidence taken down stand by the presiding judge shall be form part of the record. They will all be part of court record. So 276 it was earlier, now 311. Language of record of the evidence. So we have seen in every single case where evidence is taken down under 310 or 311. If the witness gives evidence in the language of the court, it shall be taken down in that language. If he gives evidence in any other language, it may practically be taken down in that language, and if it is not practical to do so, a true translation of the evidence in the language of the court shall be prepared as the examination of the witnesses proceeds, signed by the magistrates and presiding judge, and shall form part of the record. Clause C says where under the clause B evidence is taken down in a language other than the language of the court, a true translations thereof in the language of the court shall be prepared as soon as practicable, signed by the magistrate or presiding judge, and shall also form part of the record. (313), it was earlier 278. Procedure in regard to such evidence when completed. Now, all these provisions are general procedures which happen in the court. So, as the evidence of each witness taken under 310 or 311 is completed, it shall be read over to him in the presence of the accused, if in attendance or of his advocate, and if he appears by an advocate, and shall, if necessary, be corrected. If the witness denies the correctness of any part of the evidences when the same is read over to him, the magistrate or the presiding judge may, instead of correcting the evidence, make a memorandum thereon of the objection made to it by witnesses, and shall add such remark as he thinks necessary. So that's the working solution. Suppose someone has given evidence in a trial court, and the person who given evidence says after typing etc., when it is shown, he says, no, I have not said this. So at least idea is that the magistrate can keep the record. Clause 3 says if the record of the evidence is in the language different than from which the it has been given, and the witnesses does not understand the language, the record shall be interpreted on him by the language in which it was given or in a language which he understand. 217. It was earlier 278, now 313. 314. Interpretation of evidence to accuse or his advocate. Now, what will happen if the some witnesses given evidence to the court and it's need interpretation? So, whenever any evidence given in a language not understood by the court and is present in the court in person, it shall be interpreted to him in open court in a language understood by him. If the if he appears by an advocate that the evidence is given by a language other than the language of the court and not understood by the advocate, it shall be interpreted to such advocate in that language. When the documents are put for purpose of formal proof, it shall be in the discretion of the court to interpret as much thereof as appear necessary. So then you have 315 remark respecting demeanor of a witness. Now it was earlier 280. Remember when it uses the word demeanor, basically outer expression of a person. So his movement in the court, the way he speak in the court, the way he give an exam evidence in the court. Now question is, this demeanor of a person, it can be accused, it can be witnesses. Is it evidence? Demeanor of a person is not an evidence, but just this section earlier it was 280. Now it is 315. They empower the court under these sections to record the demeanor of a witness. So that can be recorded. Record of examination of the accused. So whenever the accused is examined by the magistrate or by the court of session, the whole of such examination, including every question put to him and every answer given by him, shall be recorded in full by the presiding judge on the magistrate himself, or where he is unable to do so owing to physical or other incapacity under his directions, and superintended by the officer of the court appointed by him in this behalf. The record shall, if practicable, be in the language in which the accused is examined, and if that is not practicable, the language of the court. Record shall be shown or read to the accused, and if he does not understand the language in which it is written, shall be interpreted to him in the language which he understood. So that's again necessary requirement, mandatory rule. It shall be thereafter signed by the accused. Then it says nothing in this section shall be deemed to apply to the exam. So accordingly, this kind of protection will not be there. 370, interpretations to be born to interpret truthfully. It's a general section, it was earlier 282. So when a service of an interpreter are required by any criminal court for the interpretation of any evidence or statement, he shall not be bound to state the true interpretation of such evidence or statement. So those basically requirement for the interpreter. So we did session trial. Now we have a high court. Recording in the high court. So every high court by general rule prescribe the manner in which the evidence of the witnesses and the examination of the accused shall be taken down in cases coming before it. So that's the High Court rules and procedures prescribe the manner in which these evidences are recorded in the High Court. Now we have a second part of this chapter, which is about the Commission for Examination of Witnesses. Look, the CRPC as well as the BNSS has made a detailed provisions for the purpose of commission appointment for examination of witnesses, and 319 to 336 they talk about different those circumstances. So 319, when attendance of the witness may be dispensed with, let me see, and commission issued, so court can a commission can be issued for the examinations. 320 talk about commissions to whom to be issued, so directions where the person will be appointed as a commissioner to record the statement. Say the witness is within the territory to which the Sanhita extend, the commission shall be directed to the chief judicial magistrate, within whose local jurisdiction the witness to be found. If the witness is in India but in a state or an area which this Sanhita does not extend, the commission shall be directed to such court or officers at the central government may by notification is specified. If the witness is in the country or place outside India, an arrangement has been made by the central government with the state government, with the government of such country or place for taking the evidence of witnesses in relations to criminal matter, the commission shall be issued in such form, directed in such court or officer, and sent to such authority or transmission as the central government may by notification prescribe. So it basically just procedures for the commission, execution of the commissions. So remember, the CRPC commission was from long ago, but is it being utilized by the court? No, answer is no. Commissions are being appointed or utilized for the purpose of examination of witnesses, etc. So it is about the executions of the commission. So upon receipt of the commission, the chief CJM or such magistrate as he may appoint in this behalf shall summon the witnesses before him or proceed to place where the witness is and shall take down his evidence in the same manner and may for this purpose exercise the same power as in trial of warrant cases under the Sanhita. 322 says parties may examine witnesses. So, in the same manner, the way they could examine in the original court, in commission also, they can do the same examination. So, 322 1 says the parties to any proceeding under this Sanhita in which the commission is issued may respectively forward any interrogatories in writing which the court or magistrate direct court or officer to whom the commission is directed or to whom the duty of execution is delegated. The examiners examine the witness upon such interrogatories. To any such party may appear before such magistrate, court or officer by an advocate, etc. Then to 323 talking about the return of the commission. After any commission issued under 319 has been duly executed, it shall be returned together with the deposition of the witnesses. So for whatever purpose the commission was appointed, that commission will be returned along with the deposition, whatever the evidence being recorded. Adjournment of the proceeding in every case in which commission issued on 319, the inquiry, trial, or other proceeding may be adjourned for a specified time reasonably sufficient for the execution and return of the commission. 325 says execution of foreign registered commission. So 325 is basically the provisions of section 321, 322 and so much of section 322, 323 as Related to execution of the commission, its return shall apply in respect of commission issued by any of the court, judge or magistrate hereinafter mentioned as the apply the commission issued under section 319. Deposition of the medical witnesses. Now, for medical witnesses, we have a special provisions. Earlier also it was there in section 293, etc. So 326 says that the deposition of a civil sergeant or other medical witnesses taken and attested by the magistrate in the presence of the accused or taken on commission under this chapter may be given in evidence in any inquiry, trial, or other proceeding under this Sanhita, although the dependent is not called as a witness. 2. The court may, if things fit and shall, on the application of the prosecution or the accused, summon and examine any such depositions, the subject matter of his depositions, etc. 327 talk about identifications report of the magistrate. So any document purported to be report of identification under the hands of the executive magistrate in respect of the persons or property may be used as evidence in inquiry and trial. This identification, there's a process which we conducted from time immemorial, but much later time we got a separate section in the CRPC which has been carried forward in BNSS in respect of TI parade, test identification parade. So what it's talking about 327 is nothing but it's talking about test identification period. So first provision says provided that where such power contain statement of any suspect or witness to whom the provision of section 19, 26, 27, 158 or 160 of BSA apply, such statement shall be used under this subsection except in accordance with the provision of those sections. Evidence of the officers of mint. Now here, remember few section has been added as a special measures that this public servant in discharging their very special duties, they have their own manpower. So 328 says evidence of the officers on mint, any document purporting to be report under the hand a gazette officer of any mint or note printing press. So these mints are where the coins or note or stamp, etc. are being security printing press, etc. are there. How their officers, etc. can come and give evidence. Remember, their evidence become important in cases when there are allegations about, say, forged document, false currency note. So, very detailed provisions, some officers are available. Then the next section is about the scientific expert. So any document purported to be report under the hand of the government scientific expert to whom this section applies upon any matter thing duly submitted to him for examination or analysis and the report in the course of any proceeding under this Sanhita may be used as evidence in any inquiry, trial or other proceeding under this Sanhita. The court may think fit someone and examine any such expert as to subject matter of this report. Now, as a general rule, remember, most of the time these cyber forensic experts are being examined. Uh, so, there can be at the district level, there may be some agencies or authorities who may deal with it, but their report can be, the section says, so it's a special measures where the section says that their report can be admissible under the law. Clause 6 says where any such expert is summoned by the court and he is unable to attend personally, he may, unless the court has expressly directed him to appear personally, depute a responsible officer working with him. So this is another power given to the forensic expert that, okay, instead of forensic director, he can send some other team member and they can give evidence. And then it talk is laid down the officer which they have mentioning. What officers? So any chemical examiner, assistant chemical examiner, controller of explosive, director of fingerprint bureau, director Hafkin Institute Bombay, director, deputy director, assistant director of Safe SL, serologist, any other scientific experts. So very detailed list is given there. Now 330 says no normal proof of certain document. So where any document is filed before any court by the prosecutions or the accused, the particular of every such document shall be included in a list, and the prosecution or the accused or the advocate for that purpose, for the prosecution or the accused, if any, shall be called upon to admit or deny the genuineness of each such document soon after supply of such document, and in no case later than 30 days after the such supply. Now 331 talk about affidavit in proof of conduct of the public servant. So when any application is made to any court in the course of any inquiry, trial or other proceeding under this Sanhita, and the allegation are made there in respecting any public servant, the applicant may give evidence of the fact alleged to in the application by affidavit. So that's the mandatory requirement when these allegations are against the public servant, then mandatory requirement of it. 332. So basically, these are the all process which are there for taking recording evidence, etc. 333 authorities before whom affidavit may be shown. So the affidavit can be shown before any judge or judicial or executive magistrate, any commissioner of oath appointed by the High Court, notary public. Affidavit shall be confined to and shall state separately such fact as the deponent is able to prove. The court may order an irrelevant matter in the affidavit to be struck out. So detailed process are there. Now this is the new section and very important section 336. It was not there earlier. So this new section added just to give benefit to the public servant. That is, the public servant want to give evidences, and sometime they they might transferred, they might retired. Now this provision is in addition to what we have seen about the other scientific expert. So narcotic drugs or other psychotropic substance, etc., biologistic experts. So we have, we have Central Forensic Science Laboratory, State Forensic Science Laboratory. So there are some dedicated work. Apart from that, 336 is a very important sections where suppose such public servant, expert or officer has been transferred, retired or died, then what will happen? So any successor in office can come and give evidences. Such public servant, expert or officer cannot be found or is incapable of giving evidences. Again, next successor can give evidences. So 336, very detailed provision.